Afternoon, we'll start the program. Good afternoon and welcome. For those of you who don't know me, my name is Danilo Vargas. I'm an attorney with Sanapi Law Associates in Warwick, and I'm also a member of the Core Advisory Council's CLE subcommittee. So a big thanks to Zach Mandel. I don't know if he's here. He's the chair of the CLE subcommittee, my fellow CLE subcommittee members, as well as Raina, Nora, and the entire court staff for putting this together. Thank you. So I'll be moderating today's panel, and my goal is to do as little talking as possible because you want to hear from these two, not from me. With that being said, our first panelist needs no introduction. Our very own Chief Judge John McConnell, who brings a unique perspective from both the bench and his many years as a trial lawyer. And our second panelist joining by Zoom is Teresa Zagnoli. And before I get into her background, I met with Judge McConnell about a month ago, and I said, Judge, if you were attending the CLE, who would you want to be a panelist? And without skipping a beat, he said, Teresa Zagnoli, my former jury consultant. So here we are, and thank you, Teresa, for joining us.
She wasn't my
well, that he used in trials when he used to try cases. So Teresa is a litigation specialist at Motley Rice. It's one of the nation's largest plaintiffs litigation law firms, where she leads their trial consulting efforts. Teresa is regarded as one of the most sought after trial consultants in the nation because of her extensive knowledge of the American juror. She's a frequent speaker and faculty member at workshops and seminars sponsored by law schools, as well as the National Bar and Judicial Associations. And her specialties include a wide range of communications and litigation consulting services. So we're talking about focus groups, case theme development, venue analysis, voir dire and jury selection, witness preparation, post-verdict interviews, as well as generally just how to communicate with the jurors. So together, they'll provide insight and practical tips for making voir dire more strategic and effective. And Judge, before we begin, is there anything you would like to add about Teresa?
Yeah, I just want you to know I'm here for my good looks because I worked with Teresa for 25 years. In fact, the whole time I was with you, she was an independent jury consultant that did jury consulting and other communications issues that arise at a trial along the way. She is, I think, the country's leading expert on both jury consultant and jury communication and human behavior, which is a whole part that we'll talk about in terms of jury picking, so to speak. And then when I left the firm, she actually came in and joined the firm and now works for Motley Rice full time. But I never did a trial. I never went to a trial that Teresa wasn't there during most of it. My biggest opening statement that I gave ever, Teresa wrote. From my perspective, you have the best of the best. I will occasionally add a little humor. And if Teresa really lets her hair down, I'll make fun of her because she'll make fun of me, which is part of our relationship. But you're in for a real treat just because of how well she communicates, but you're also in for an incredible learning thing. And just so that you know, while she's working for Motley Rice, which is primarily a plaintiff's law firm, other than Motley Rice and a few others, Teresa did a lot of work for big firms representing big corporations, people that maybe now she refers to as the bad guys. So her perspective applies completely. One little caveat to my friends in the criminal law bar, she did tell me early on that she does not have specific criminal experience. So I just say that as a preface.
Thank you, Judge.
Go ahead, Dan.
Thank you. So the way this is going to work is we'll have about 50 minutes of moderated questions, and then we'll reserve the last 15 to 20 minutes for questions from the audience. So with that being said, let's get started. So this initial question is for both Judge McConnell and Teresa. Teresa, we can begin with you. But starting with the basics, what do each of you see as the real purpose of voir dire? And by that, I mean, is it just picking a jury and striking jurors, or is it more about shaping how jurors think right from the outset?
So my advice to my clients over the years has not been to spend your time during voir dire or jury selection trying your case. That you will be afforded weeks, days, months, in some cases, to try the case. And that you only have an hour, 2 hours, half day to be able to figure out what biases might potentially exist on that jury. And a bias cannot really be overcome. If somebody has a strongly held opinion, then you're not going to change that. I mean, you're not going to change my outlook on Catholicism. I was raised in the Catholic Church. I have an Italian background. My father organized unions for a living. Those are biases that I hold. And so you may or may not want me on a particular jury, but you need to find that out. And so that's what I believe jury selection is for, especially in federal court with only 3 strikes generally per side. It's very hard to change the makeup, the composition of the jury with only 3 strikes. So you've got to really dig around to look for people's bias and use your challenges for cause and work to find out what people are thinking.
Yeah, I couldn't agree more. I think what I've observed on my almost 15 years on the bench is that most attorneys that appear before me believe that jury voir dire is about getting the theme of their case or a particular theme across to the jury. And I find that to be incredibly wasted time that's done. So what is the purpose of voir dire? The purpose of voir dire is a fewfold to me. One is to strategically use your 3 strikes or in the case of criminal 10 or 6 context. How do you strategically use those? What information can you get from the jury in questioning? And we'll talk more about that, obviously. So that should be your number 1 goal. In my opinion. The second is that I don't think most people effectively use voir dire to support a cause strike that they want or to support a juror that they want who may be subject to a cause from the other side. I've yet to find many lawyers that effectively will rehabilitate a witness, and Teresa can talk more about how you do that. But I think that's one of the main purposes. Evidence for your strikes to support the jurors that you believe you want on the jury, to uncover the biases, and then importantly, again, thing we'll talk about, and again, everything I learned from Teresa. And then living with the results of Teresa's work, because I had to take the verdict, is identifying leaders and thinking about the group dynamics, because jurors don't act alone. Jurors act collectively. And again, Teresa will talk more about that substantively, but to me, that's the purpose to uncover biases, to support strikes, get information and ask questions in a way to support your strikes, how to rehabilitate your folks, and lastly, to identify what the group dynamics will look like in your jury, most importantly in terms of who will be the leaders. We can talk, again, I'll talk more about that, but that to me is the purpose of voir dire.
Thank you, Judge. So Judge, obviously from the bench, you want attorneys to accomplish that purpose. But I'm sure sometimes attorneys will ask questions or do certain things that don't serve that purpose at all. And is there 1 or 2 things that you would wish they would just stop doing?
No, I want to put it positively. I wish lawyers would start listening. The vast majority of lawyers that, and I apologize if some of you, I don't see any right off the bat that have tried cases before me, but I apologize, but I'm going to give you my best advice. Lawyers don't listen to the answers, period. They don't. None of you do. And it's either nerves or it's fear of engaging with the jury, or you're afraid of the topic. Biases are, tough things to talk about. So I wish lawyers would listen to the answers and use the information. Because my favorite is when a lawyer asks a tough question and then the person begins to answer and they look away and they're starting to already write down. So the person's not going to give you an honest answer. You're not going to be able to read them without that kind of proper eye contact. So listen.
Right. Or somebody says something like, well, yes, I have 13 grandchildren. And the lawyer said, thank you very much, Ms. Smith. And Mr. Jones, how many grandchildren do you have? Come on. You got to react like, wow, 13 grandkids, where are they all? So just being interested in that person. We've all read or heard of Stephen Covey, and one of his most famous lines in his books is try to be interested, not interesting. And that's so many people who get up in front of a venire, they try to be interesting. And the best way to engage somebody is to be interested in them.
I like that. Be interested, not interesting.
Yeah, I like that.
I like that. Sticking with the initial goal over here, Teresa, when you're first advising an attorney, what's the initial conversation you have about voir dire strategy beyond just, getting rid of bad jurors?
Right. Well, so the initial conversation is, who is not going to listen to us no matter what? So what kind of a bias, and this is what I'll tell you about the obesity comment that I made. You have to be able to ask the tough questions. So I was in a Rhode Island court, I believe, and I said to the lawyer, you've got to ask about if anybody has a bias, an obesity bias. Obesity bias is the only bias since the 1970s that has actually increased and not decreased. So, and it is the second most prolific bias that we have in this country. And this person had a client who was obese, and there were issues with the case that marginally dealt with the obesity. It wasn't the main focus of the case. And I said to the lawyer doing the voir dire, you have got to ask whether anybody has a bias against obesity. Like, have you made fun of people? What have you said? Do you think people just need to get off the couch? And do you think, and this was not weight loss drugs or anything like that. It didn't have anything to do with anything related to being obese. And he was frightened. He was scared to death to ask the question. But he did. He asked the question, and most everybody said, oh yeah, I'll be fine, I'll be fine, I'll be fine. And sure enough, a guy in the front row raises his hand and says, yes, I do. I feel uncomfortable. The people who are overweight make me uncomfortable. People who are overweight, it's mostly their own fault. And so it really didn't matter what the cause or the underlying reason of his bias was. He had a bias against obesity. And so one of the first conversations I have is, what are the tough questions? I mean, let's look at this. I have never in 40 some years stricken a juror because of how many children they have. Like, who cares? Unless you're doing a child products case, a juvenile products case, or if you're doing something that has specifically to do with children, there are so many questions that just don't matter. That have become rote. They just get asked jury selection after jury selection after jury selection. And unless you're going to strike that person because of that fact about their background or their belief, or if you're going to somehow take an expert or take testimony and try to tailor it, try to match it up to that fact, then why are we asking those questions? It's just, they're just dribbled.
Thank you, Teresa. That kind of actually goes into my next question, which you answered in part, and that is how to get jurors to go beyond just a surface level answer. So I know it's about asking the right questions, but are there any additional tips that you have to get the jurors to really answer truthfully and deeply?
Well, one thing is I recommend, unless you have to, do not have your client in the courtroom. So if you're representing,
Teresa, can you say that again? Because I was shocked when you first mentioned
okay,
that to me, and I don't think
So-
most lawyers would
so
understand.
if there are issues that are touchy issues, for example, if you're defending a pharmaceutical company, leave your corporate rep out of the courtroom and then really dig into how people feel about pharma companies, how people feel about corporations. You know, when they sit around the Thanksgiving table, do they talk about what corporations are doing to America? Do they think corporations are more helpful or more hurtful? Do they think lawyers are more helpful or more hurtful? So you try to offer up a question that will give a one or the other, not just a how do you feel about corporations. So it's really important to get people talking like that. The other thing is to start out with questions that everybody can answer. So start out, what's a good example? So if you're in a meeting, if you yourself are in a meeting, and let's say you're the odd person out. So you're either a new lawyer to the firm or you're with a new client, and there's 7 people from Apple in the room, and you're defending Apple, and you're the only lawyer there, and 45 minutes have gone on and you haven't spoken. You might have had something really great to say 45 minutes ago, but by the time that builds up and the expectation of what you now have to say, in your own mind, you've built it up as being this big hurdle to get over. And everybody else is kind of feeling the same way. Now, if you speak, it needs to be something monumental. Well, if you let your jurors sit there and talk about yourself for 10 minutes, talk about your case for another 10 minutes, talk about, the fact that you've been to Rhode Island Beach on vacation for 5 minutes, then you've now shut 40, 50, 60 people down and not given them the opportunity to talk. So I try to find questions that everybody can answer. And it somewhat depends on your judge or your courtroom as to how you do it. Are we going to go one by one? Are we going to ask open-ended question? Are we going to ask, Judge McConnell, where are you, what do you like best about Providence, Rhode Island? And then he speaks, and then you step back and you go narrow to broad, and then you say to everybody else, okay, so you heard what Judge McConnell likes best about Providence, Rhode Island. What do the rest of you like about Providence, Rhode Island? Or you start broad. So let's start talking about what people like in Providence, Rhode Island. Raise your hand if you like that it's close to the water. Raise your hand if it has a history of a strong Irish background. And so it just depends on what you're allowed to do and what your goals are. But you want to get the audience involved as early as possible. It's kind of like being a stand-up comic. The more you can get your audience to go with you, go with the flow, then the more information and the more interaction you're going to get.
Thank you. That's very helpful. So just to follow up on that. So I understand what you're saying about not having a client in the room, which is, the jurors will be.
Oh yeah, that's where I was. Sorry, I lost track of myself.
No,
so if you don't have the client, in the room though, that frees up people's opinion. And I didn't do this for probably 15 years, 20 maybe. Well, I've been at this for 40 some years. So it took a long time for me to buy into this. But I have completely bought into it over the past couple decades, is leave the plaintiff, leave the defendant. Obviously, if you're the government, you can't leave the government out of the room, but to get people to be able to open up. If we had the obese person sitting there in the room when we asked the obesity question, I can't say what would have happened, but I can guess that we would have been less likely to get an honest response when somebody's sitting there and has to say, yeah, it's your fault that you're 100 pounds, 80 pounds overweight. So that's why when it fits the situation, one way to get them to open up, in addition to the other things I said, is to leave the client out of the courtroom. The other thing, I'm a huge proponent of juror questionnaires, and they don't have to be 40 pages long. I can do one on 2 pages that get flipped over. In fact, I don't want a questionnaire that's 40 pages long. I want the format tight. I want it so that I can just look at that and I can circle the 2 answers that I want somebody to follow up on. I want the lawyer to follow up on in voir dire. And that also, so you can say to the juror, Ms. Baker, on your questionnaire, you said XYZ. And I would just like to follow up on that now. And so she now knows that you're interested. She knows that you've read her questionnaire. She knows that you've read her questionnaire and you've actually paid attention to it. Because a lot of times, we'll convince the bench to do a questionnaire, and then the lawyer, for one side or the other, gets up and starts asking the same questions over again. And it's like, well, didn't you read the questionnaire? But if you use that, it's a great tool. And people are, the field of psychology and the field of communication research, which is where I'm grounded mostly, is in comm research, is those 2 fields will tell you that people are more honest in writing than they are verbally. Because verbally, they can get away with saying less. In writing, they know it's going to be, if that's a record of what they say. We also know that the greater the authority in the courtroom, so the judge is the greatest authority in the courtroom, the more socially acceptable the response will be. So the judge asks the questions. I'm gonna do my best to hide my bias or deny my bias. I might not be hiding it. I might just be denying it. So to deny my bias, the lawyer is the second next authoritative source in the courtroom, or authority source in the courtroom. So maybe I'll get a little bit more truth out of them. But a written questionnaire, you're going to get the most honest responses. Now, we know through the research in the communication field that and people don't believe this, and they find it shocking, 30% of the time spent in a day is either telling or receiving lies. That's the average. Now, does that mean that I am a malicious person or that I am a liar? No, but I like your tie. You look great. No, I can't go to dinner because it's my child's birthday. Well, maybe it is, maybe it isn't, maybe I just don't want to go to dinner. So there's a lot of this haphazard lying that goes on, and thus we live in a society that accepts half-truths and untruths. And it's difficult to expose yourself in a courtroom, especially a federal courtroom. I mean, that's a big deal. Most people have never been in a federal courthouse, let alone inside the courtroom. And so it's a really big deal. It's scary. I took years ago, I took one of my sons to a trial, to an antitrust trial. I know, I'm a great entertaining mother. To an antitrust trial, just to see the courtroom and what I did and what I do. And he was scared to death. And this was a pretty fearless child. But that's how the jurors, it doesn't get much better when they're 35, if they have never been exposed to this atmosphere, this scenario. So you do have to work at opening them up. You do have to talk to them. You don't have to make friends with them. They're not going to be your friend. And don't act like their friend. Don't be hokey. Don't say, well, I've been to the beach here, and so my grandmother, used to bring us here every summer, so I feel like I'm a Rhode Islander. Well, you're not. If you're from California, so don't try to act like you are. But you can be polite. We did surveys years ago, and the jurors, we did about 1,200. I think the sample size was about 1,200, and what they liked most about lawyers was the one of the factors. There were three factors: preparedness, and politeness was one of them. So if you're being polite and gentle and kind and warm and you have credibility, then you don't have to be hokey and try to make friends where you don't need a friend or are never going to get a friend.
Can I just interrupt? Teresa, can you talk a little bit about, in a real practical way, how one should question a jury, either individually or the group as a whole, on the issue of a particular bias that's of concern to you, whether it's race, whether it's gender, whether it's corporation, anti or pro, or whatever it happens to be that is the bias that has you concerned in your case. What do you suggest the lawyers do in questioning to draw that bias out? How do you ask the question, and what question?
Sure. Well, let's take I'm trying to think of a universal example. So let's take race is very difficult to do. There are not very many people are going to raise their hand and say, I'm a racist. So this is where a questionnaire is helpful. You can ask if, do they have friends from different cultures? What cultures? African-American friends, Hawaiian friends, Eastern Asian friends. So you can do something like that, but take something that's more lawyers. Take lawyers. So there's a question that we use, and it is, do you think that lawyers harm society or help society more? And you got to get in there and dig around. You've got to say, you got to get the person to answer that. Do they help or do they hurt society more? And if they help, how do they help? Well, they help in civil rights cases. They help because people sue big corporations because they have deep pockets and somebody's got to defend them. So you find out why they help. Now, do they hurt society more? Well, yeah, they're thieves. They're ambulance chasers. They charge enormous amounts of money. They double dip. So you start to find out how this will affect your case. I worked on a case a couple years ago, and I don't want to tell war stories, but we had a juror who hated lawyers. He said in deliberations to the other jurors, I hate lawyers. I don't care who wins this case. I don't care who loses this case. I'm not helping to make a decision. And he hung the jury, this one juror, and it had nothing to do with the case itself. He hated lawyers. And we missed it. We didn't get it out of him in jury selection. I mean, there are things you're going to miss. But that's why you have to get in and dig for the biases. So you got to come up with a question. I guess to answer your question more directly is you have to have a question that gets right to the issue. So for example, the criminal work that I have do is usually on the prosecution side, and it was generally for the federal government. So I did the Noriega, helped prosecute Noriega, helped prosecute several drug lords, and this has been 30 years ago. In Miami, some of the antitrust work that the Justice Department did, and you've got to go in on a case like that, and you've got to really find out. You've got to get people talking, and where are their bias? Do you easily change your mind? Where do you go for advice? Do you go to your friends for advice? Do you go online for advice? Do you ask your doctor for advice? So, and if a person says, no, I usually just make up my own mind. Well, all right, you have a very dogmatic person then sitting on your jury. Now, maybe I want somebody dogmatic. Maybe I want 8 dogmatics, but probably not. I want somebody who's going to listen to the facts of the case and to look at the evidence. And you can't load a jury. I mean, if you ever could, those days are long gone. So you've got your strikes, you've got your challenges for cause, and the best you can do for your client is to ferret out those biases. And there's so many types of bias. There's hindsight bias, where I've held this opinion all of my life, and now what I'm going to do is to get the evidence. I'm going to take that evidence and I want it to fit into the bias that I already hold. And so using words like fair, using words like bias, using the words that are actually sitting in the law are not going to get us to what we want. Now, that may be how we get our challenge for cause, but it's not going to get us the information that we want. And once we get the information on a bias, then if we can turn it into a challenge for cause, great for us. But maybe that's where we put our strike. I always when there's only 3-4 strikes aside, it's usually pretty easy to decide who those 3 people are going to be. It's not that you probably don't need me. But to show that, and I work towards a pattern of bias. So I'll do a list of questions for a case. And then, so let's say that I have a juror that answers my four special questions for that case, that they answer them all against me in a way that shows their bias against my case, my client. Then what I'll do is we'll go to the judge and we'll say, Your Honor, if this person just didn't like big corporations, that would be one thing. That's a bias. If this person didn't just say that they were a liberal voter, that'd be another thing. The person has said that he or she does not want to sit here, does not want to judge other people. So now I've got a pattern to work with. I can go to the judge and I can say, look, I've got this Ms. Henshaw doesn't like corporations. She would never work for corporations. She thinks that corporations favor profits over people. And she has admitted to saying that corporations are more bad corporations than good corporations. And so we say, so Your Honor, maybe one of these biases I could overcome, but I can't overcome four. I can't overcome a pattern of bias. And if you really do have a person and you've had an honest and good exchange and they've shown this pattern of bias, it's much better for the judge to decide that person needs to go than to make that person continue to defend themselves or continue to expose, to try to hide a bias. It's just unfair. There's plenty of jury. They can go sit on another jury. They don't have to sit on that particular jury.
Thank you, Teresa. And so shifting the discussion just a little bit from the individual juror to group dynamics, what role do group dynamics play in jury selection? And by that, I mean, how do I identify natural leaders or influencers in a panel? And Judge, I would also like to hear your opinion on this because I've heard some good examples from you in the past.
Well, let me just actually start saying group dynamics is everything. I mean, by the very nature of a unanimous verdict, group dynamics either get you to a unanimous verdict or get you to a hung verdict. The individual actions all by themselves are different. And Teresa's partner at the time when I was trying a case, this juror number 2, he didn't believe in our case. He didn't really like lawyers. He particularly didn't like plaintiffs' lawyers. He kind of, thought things were too high and whatever. And we go out at the break, and I said, it was Pat, Teresa. I said to Pat, I said, oh, Pat, all right, so we got to use one on juror number 2. And she said, no. Juror number 2 is never going to hold this jury up. Juror number 2 is never going to lead the discussion in that courtroom. Juror number 2's opinion is almost going to be irrelevant in that room. Leave them on. You've got a questionable leader who I'm not really sure whether they like. This was kind of a big case that was well known. I'm not really sure. You really have to get rid of that. And I got to tell you, it took me. I mean, I nearly gagged on accepting juror number 2 on Pat's advice, and she was 100% right. It is all about group dynamics. How are those 8 people in a civil case, 12 in a criminal? How are they going to act together? Who's going to lead it? Who's going to be the voice? When you're in a group and you go around giving opinions, right? Oftentimes, the first one to speak or the loudest one to speak, many people just go along because they don't want to look like an idiot, or they don't want to look dumb, or they haven't really formed an opinion. And so you've got to be really worried about who your leaders are and whether they have significant biases against you. Because I'll give a classic example of, we had a medical malpractice jury, juror number 1, was many things, but she homeschooled her children. And I see the world of homeschooling in like 2 maybe three ways, right? There are people that homeschool, and if I can just be quick here because we don't have a lot of time, granola bars. I'm the parent. I'm going to teach them from the earth and experience, and I want to do this wonderful, beautiful thing. There are homeschoolers that are anti-government. I am not sending my child to the government. It's not happening, and whatever. And obviously there are people in between. They had no idea which homeschooler this was. It came back a defense verdict. And I always speak to the jurors afterwards, and a civil defense verdict. And I just said, how was it going? And all the other seven kind of just sat there, and this homeschooler just started espousing the defendant's position. And no one else responded at all. Not a single one of them responded at all. And then when I tried to draw it out a little bit, it appeared that most of them probably were sympathetic to the plaintiff. I don't mean had sympathy, but were gearing toward the plaintiff's position. And this woman just led them the other way. And they were all go-alongers, if I can call them that. And it came out a defense verdict. But for that leader, now, if she weren't the leader that she was, or there were other leaders, then it would have been a different verdict. That's my classic example of worrying about who your leaders are more important than not. How you determine that, Teresa can respond to.
So here's a mistake I think that gets made all the time. You look at what they do for a job. They ask this question, which I have never personally put in a voir dire or in a questionnaire. How many people do you supervise? How many people have you ever supervised? It matters not. We all have. Think in your head, your friend never has supervised anybody for anything. Maybe she's even a stay-at-home mother, but she's organizing all the family parties. She has the big 4th of July party every year with a band and fireworks and all of her kids. That woman is a leader. And the mistake I see all the time is you go to the profession, you go to how many people they supervise, whether they've been in the military before, and you make these judgments on this person without ever hearing them speak, without watching them walk, without seeing how they're sitting. I mean, this is when nonverbal cues are pretty telling. When you watch how somebody sits and walks and interacts with other people. So that's the first thing, is that don't confuse a job, a career, with leadership. The second thing on group dynamics and leadership is that there are different kinds of leaders. Like, there's always this big debate. Who will be the core person? Who will be the core person? Like, I don't know. You've got different kinds of leaders. You've got social leaders. You've got intellectual leaders. You've got rule follower leaders. And so it depends. Is your case teetering on the jury instructions? Like, do you really need them to follow the jury instruction number 6 to the letter? Then if that's the case, you want to try your case to that jury instruction. But before that, you want a group dynamic. You want somebody who is a rule follower. If you got instructions that are not in your favor, then you don't want to look for rule followers, or those aren't the people that you're going to excuse. So that's I see that all the time. So that actually goes with the idea of leaving somebody on the jury that is not going to lead, which is the example that Judge McConnell just gave you. So there's just no reason to waste a strike. They are precious in federal court. They are so precious. And you shouldn't waste them on somebody because you just don't like the looks of them, or what they do for a living, or their religion, or their political party, or you have to dig down into that. But so I think the danger, go ahead.
Can you just give some practical examples of questions that you would have to bring out the leadership issue that you highlighted?
Sure. So, I think I'm going to find out if I want to know anything personal, I'm going to want to know whether or not they, so brothers and sisters, what do their parents do for a living? I always like to know, even if you're 60 years old, I want to know what your parents did for a living, because I can make judgments. So let's say your parents are your parents a doctor and your parents a lawyer, and you run a small window cleaning service. Well, that tells me something about the fact that you've got two professional parents that have sort of stepped on you your whole life. And even though you own a business and you may supervise 25 people, you may still not have leadership qualities. And there could be other questions that go along with that. But this is where you get into the psychology of people, and what makes them who they are. National Jury Project, who has if you don't own National Jury Project's set of volumes of books and you try cases, you should run out and buy one. But National Jury Projects were really the very first organized trial consultants in the country back in the 70s. And they started with Wounded Knee and the Chicago 7 and all these sort of civil rights cases, believing that the government had the advantage. And they were good socialists, and they were going to make sure that the defendants in these cases that they had the advantage too. But they'll say, and they say it more eloquently than I can, but it's not the experience of a person. So it's not that I supervised 50 people or 500 people or 25 people. And by the way, if they supervised 500 people, they didn't supervise 500 people because that's impossible. So they supervised one, who then supervised four, who then supervised those four, supervised another 12. But they'll say it's not the experience, it's how that experience affected you. So if you can get past, so if I think you're a leader or not a leader, and I'm trying to find out because I'm going to use my strike on you, or if I'm worried that you're a leader in your mind, but you're an obnoxious leader, I need more information. So yes, you're the boss. Yes, you own the business. Yes, you have 25 employees or 40 employees or whatever. But how has this experience affected you? So when you go home at night, who's the boss at home? Your husband or you? Which one of your kids take after you? What do they do? Oh, and they turned out they're going to, they're in school in Europe. They're backpacking in the Himalayas. So you're just gathering information. The whole time you're gathering information. And you have to do it quickly, and you have to do it with interest. And if you get too far out on a limb, if you're asking questions that make absolutely no sense to the jurors, then they start to wonder what you're doing. You're just prying for information. So it's tricky. Another survey we did of, and I think this is how old it is. It was when the plaintiff's bar was called ATLA. That's been a long time ago, right? And we did a survey at a national convention one time, and of all the different parts of trial. So opening statements, closing arguments, cross-examinations, depositions, all the different parts. And voir dire, jury selection, was the Achilles heel of the respondents to this survey. And it is, as Judge McConnell said, it's for a lot of different reasons. It's you don't want to interact, you don't want your somebody to say something bad about your client or the case or the situation, but it's you have to have it to get the information. And that's how you find out what the group dynamic is going to be. Federal court's nice because you can see the jury, and for those of you who practice in state court and the courts where they use the struck system, you can see the jury in the box. Like you kind of know who's going to be there, and they're not moving people around all the time. And so you can say, well, we're going to strike this one, that one, and this one. We think that the plaintiff will strike that one, this one, and this one. So that's what's left. And that's nice because you can look at that group dynamic. And some courtrooms and some cases where you've got 8 defendants and everybody gets 3 strikes. And then the plaintiff gets, so both sides get 12 strikes. You got to get rid of 24 people. And I've sat juries and embarrassingly so, the jury comes back and it's the 8 or 10 or 12, whatever people to be sworn in. And I look up and I think, ooh, who's that? Where did that person come from? Because we haven't talked to them, because we've gravitated toward the talkers, or we've gravitated toward the people who are fulfilling our own personal need to succeed at the voir dire as a person instead of a jury picker. Did that answer?
Absolutely. Thank you. I do have one follow-up to that, which is you mentioned tricky questions. And I understand, you know, as you discussed, the questions that are just kind of a waste of time. But are there certain questions or things that lawyers do during voir dire that kind of backfire in a way? It kind of taints the whole jury pool. Do you have any examples of that?
Yeah, I gave one. Hometowning. Try to act like you're local when you're not. I it's just, it's so foolish. You are not part of that jury panel. And if you are from Iowa, or if you're going to Iowa to try a case and you live in Massachusetts, don't try to act like, because you went to the Iowa State Fair 3 times when you were a kid, that makes you an Iowan. I see it all the time. People try to hometown themselves, and you just can't. And the more rural or the smaller the community, the worse it is. So that's one mistake. There is a rule in communication about self-disclosure. And I've actually seen this done very well by judges, good judges all over the country, and by some lawyers. And they will self-disclose something about themselves. So, and this to try to elicit a potential bias. And they'll tell a story about their mom or their dad or their childhood or their husband or their wife and say, you know, that makes me, and they use soft language. So that would make me prone to listen a little harder to the plaintiff, or that might make me feel empathy toward the defendant. You know, I've been sued, and so I get that. And a little self-disclosure can go a long way. Too much self-disclosure is just you up there talking about yourself to no end. And you don't know when to stop talking. So self-disclosure is a good thing. And sometimes it can make people comfortable, because you want people to be comfortable with disagreeing with you. You want people to say, I have a bias against obese people. I want people to say, I have a bias against plaintiffs' lawyers. We want people to say we have a bias against corporate America. We want that. And that juror, because that juror holds that opinion, they're not going to change anybody else's mind. So the other mistake is not asking the hard questions. So is thinking that because the juror spouts a bias, that now all of a sudden, ooh, everybody on the jury is going to believe this. Everybody on the jury is going to be biased. It just doesn't work that way. These are ingrained in us for years and years and years of thought and study and work and life experiences, and having one person say, oh, well, I think semi trucks just roll everybody down on the highway, and you know they should have to stay in the right hand lane all the time. And I hate when I get up next to one. So what? I mean, that's not going to change anybody else's opinion. They all have their own experiences and opinions to work with. Can I just talk? I don't have a clock in front of me, so I don't know how much time we have. But there are 2 things that I wanted to cover today that I thought were really important. And one doesn't happen very often, so it's not going to apply. But when it does apply, you need to notice. And that is if you're trying to get a change of venue. So part of what I've done is I do research, and then I either support for or against motions for change of venue. And I do the research, we do the statistical analysis, and we do and then we testify. Here's the thing, is that it is generally accepted that if you have a bias of more than 30%, it is very difficult to clean that out of a jury. Unless you have a judge who's going to acknowledge that bias is probably sitting at 35, 40, 50% of the people already have a bias coming into this case. And then you work with that judge on your challenges for cause. You work with that judge on his or her questions that they want to find out to see what this bias is. bias is not good for anybody, you guys. It's just, you get bad verdicts. You make bad law, bias is not a good thing. So that is the one thing I wanted to mention. Even if you're not trying to get a change of venue, if you're out there doing jury research, or if you're reading polls, just opinion polls in your local newspaper about topics that might be close to the edges of your case, I look for biases that might be out there that are more than 30% biased, because you're going to have a hard time. So you've got to have a different strategy going into jury selection. So that was the one thing I wanted to talk about. The other one that I want to make sure that I get in is ask your judge to talk to your jurors after the trial. So many times the verdict comes in, and sometimes if the verdict takes days, I don't stick around to closing argument, jury instructions, I'm out. And I'll say, well, what do the jurors have to say? Well, we didn't talk to them. Well, did the judge say you can talk to them? Well, we didn't ask her. No, you will never get any better if you don't have good feedback. And a lot of judges will do it for you. They'll just ask, you just need a few questions to really know what the jury thought of your case. But it's, if you don't, you let's say you get the verdict that you desired. And maybe you're a person who does medical malpractice cases for a living. Well, I guess you wouldn't be doing it in federal court, but anyway, you do med mal cases for a living. So now you get the verdict you want, and your doctor and your hospital, your caretakers, they're all off the hook. You get a defense verdict. Unless you talk to that jury, you don't really know why you got that defense verdict. You don't have any idea. You can guess why you got the defense verdict, but you really don't know. So nudge your judges to either talk to the jurors themselves, and I know Judge McConnell does, but he is not. He's not necessarily the norm. It takes somebody who is curious, wants to know, is willing to get in the time, and then if he or she, if your judge doesn't want to do it, ask if you can call the jurors. Ask if you can talk to the jurors. Many times the judge will say yes. Go ahead. Now, he or she might also say to the jury, if somebody calls you, you don't have to talk to them. Well, that's fine with you. You don't want to talk to somebody who doesn't want to talk to you anyway. So, but really work at figuring out ways to follow up and find out why you got the verdict you got. Don't just accept that it was a plaintiff's verdict or a defense verdict. Go find out why, and specifically why. And then maybe you'll either fix it or you'll be able to, I always said, just because you danced and it rained doesn't mean that the dance caused the rain.
Teresa, what do you advise your clients on how to deal with a judge that will attempt to rehabilitate, Attila the Hun with the but you can be fair, or will you promise me that you'll be fair question, because we want to move this along, and we don't want to we want to move it along. Right. It is the
ultimate barrier. It is the ultimate barrier because lawyers tend to be afraid to annoy the judge. What I recommend is that you take the conversation in camera, take the conversation to chambers, take the conversation away, and you have to make your case to the judge. And the judge will try and say, but he said he could be fair. He said he could be fair. He said he can put his bias aside. And you've got to be able to argue the social science. It's not just arguing the law. So you have to build upon the social science that talks about biases and how they can be gotten rid of, and the number of biases. And all you need is like a little cheat sheet. Have somebody spend a Sunday afternoon going online looking up all the reasons for different biases, and really educate your judge, because we all know the worst reason to do something is continue to do something is because we've done it before. And it's just, I know there's some judges that will not be educated, that will not be moved forward, that just want to do it the way they do it, and they want to rehabilitate, and they think people are just trying to get off jury duty, and they think everybody should sit on jury duty. but you have to plead your case that it's just not fair that you should have to climb this hill. And there's usually in the law books, it says you deserve to have an unbiased jury. And just because a person says they are unbiased does not equal that they are unbiased. Now in some states, you can't rehab. Once a juror says, no, can't be fair, that's the end of it. You're not allowed to rehab. So nobody can rehab. The judge can't rehab, the lawyers can't rehab. It is the ultimate hill to climb is when the judge, because the person is going to say, okay, yes, I can probably be fair, unless they really, really don't want to sit, but you've all seen it. Judge McCall, you've seen it. I mean, people they fold at some point, they fold. And you want to avoid that fold. So whenever you can speak, whenever you can get in there in the crack and say, I see that you're hesitating. Watch their nonverbals and say to the person, the juror, and say, it took the judge, he had to ask you 3 times. And I'm uncomfortable because I think you're uncomfortable. So when you start to put your own emotions in front of that juror, sometimes you'll have just a little bit more success. And sometimes that's all it takes is just success with 1 or 2 jurors.
Yeah, one of the things that I wish more people would do would be to, if I've come to that conclusion, ask me, could they inquire further? And then either you're trying to rehab someone or you're trying to strike them, right? And depending on it. And that's when you do your work as an advocate, right? The best. And one other thing I want to mention, Teresa, that you have mentioned, which is if asking the tough questions, if engaging with someone that you don't know at all on a personal level, which is what you have to do to get the best information for it, don't do voir dire.
Right.
Get someone else to do it.
Yeah.
Right. You can be an awesome trial lawyer in your head and not be particularly comfortable at voir dire. That's okay. Masters of the universe out there.
Yes. It's
okay. Find the person in your firm. Find your co-counsel that is good. They may not be really good advocating in a courtroom, right? They may not be, but they may be really good at that human interaction. They may be, because that's where people are going to be honest with you. And that's conversation is where you're going to draw out these biases. Because that, again, you've got to be able to engage it, and you can't be willing to accept an answer, particularly if you have a reason to think that this person has a bias that's either for or against you, right? You've got to be able to engage them in that level and be uncomfortable with it. And if you're not, then don't do it. Just don't.
Yeah, I don't know what class in law school is the class that says you have to be able to do everything, but don't take that class. It's just not right. It's just you don't have to do everything. And that's the other, if you show, I think I might be repeating myself, but if you show the juror your own discomfort. So let's say you're all at the sidebar, you're trying to get a challenge for cause, judge is on the bench, there's 3 lawyers over here, there's 3 lawyers over here, the poor juror's stuck in the middle of getting everything typed down that they're saying, and your judge is trying to rehab, and you've got to go in for the one last question and say, Your Honor, can I just ask one more question? Please, please, please let me ask just one more question. Most of the time, unless it's really grumpy and you've just done something that's annoying for the past 5 years in front of that person, they'll say, sure, go ahead, ask one more, that's it, just one more. Each side gets one more. And if you say to the juror, if I say, Ms. Beaverton, I am really uncomfortable right now. I know you just told the judge you could be fair. I know you just told the judge you could set aside these feelings you've had, but I am just really uncomfortable. And I am afraid that if we don't get to the heart of this bias, then you're going to sit on a jury and it's not going to be fair. You're not going to be fair. It's not going to be fair Mrs. Williams or whatever the client or the plaintiff or the defendant is. And can you just honestly say, are you absolutely certain that this bias, which you've already told us about, is not going to niggle its way in? It's not going to affect how you see the evidence. It's not going to color your glasses is a really good phrase, especially when you're with an older person. It's not so much a young person's thing, but we look at the world through colored glasses. And is that not going to color? So really soft pedal, and more times than not, 100%, but more times than not, that person will, they'll suddenly get wishy-washy again, and they'll be like, yeah, no, that's going to bother me. I don't know. And then, like Judge McConnell said, then they go and they sit down, juror sits down, then you got to really argue and say, come on, Your Honor, you saw she's waffling. She wants to please you. She wants to please me. She wants to please us all. But this is going to be there when it comes time when I have to look at this person every day and try this case to a person who I know already doesn't like my client. Something to that effect.
Thank you, Teresa. So before we open it up for questions, Teresa, the information you've given us is amazing. I was just realizing that I took so many notes down that now I can't read my own handwriting. So I'm going to have to watch the recording later on. But with that being said, just to kind of summarize a little bit before we go into questions, what would you say is the top 3 things that lawyers should be doing before going into trial in order to walk into voir dire with a smarter game plan?
One thing is profiling jurors has become pretty antiquated and impossible to do because of the society we live in. 30 years ago, if juror number 6 name was Maria Blonkowski, and I'm in Chicago, Cook County, I can tell you where she lives, practically what block she lives on. I know her husband's either a plumber or an electrician, but is a tradesman, is a blue collar worker. I can tell you where she shops. I can tell you she's Catholic. I can tell you how many kids she probably has, but that is just gone. That is gone from our society. We are no longer, or we have become a homogeneous society. So the woman making, I don't know what the income levels right there, but so the woman making $60,000 a year at her clerk job in the office, the assistant job, and the woman making $250,000 a year are now today wearing the same perfume. One of them is buying it through Amazon at a discounted price or at the local Kohl's or local whatever, and the other one's going to Bloomingdale's to buy it. But we have access now to so many things that level the playing field for people. So first thing we do is stop worrying about who we want on the jury and look at what bias is out there that is going to prevent a juror from deliberating the facts. Because a hung jury is not good for anybody. Even if you're the defendant, your client doesn't want a hung jury, more than likely. You don't want to try it all over again. And so a hung jury is not a good thing. So you're trying to develop you can call it a profile. I rarely call it a profile, but you're looking for people who are not going to identify with your case, identify with your client, or identify with the damage that you're claiming if it's a civil lawsuit. So who is not going to identify with those very important things? Because the bias against those is more important than any opening statement. It's more important than any one expert witness, than any hot document, than any list of facts. So you sit down and you say, okay, who is not going to like my client, my case, not you? I mean, it's nice if they like you. That's always good, but it isn't the end all be all. Just have them not like you. Who is not going to like this? So that's number one. We write down what is the bias that we need to get rid of. The second thing is make your list of voir dire questions and actually ask them to somebody. If you have a fifth grader at home, ask them to the fifth grader, but make those questions come out of your mouth. I don't know about this group of people, but usually when I speak to people, I ask, I have people raise their hands. How many people have been in court in the last 3 months? What year? Jury selection. How many have been 6 months? How many have been a year? And you know what? I get to 5 years, and that's when all the hands go up. People are coming into court and doing a voir dire once every 5 years. Well, there's nothing I do that if I did it every 5 years, if I only rode a bike every 5 years, if I only practiced my profession every 5 years, I wouldn't be that good at it. So when you're, you take depositions every day, all day, you're really good at asking questions of people on the record for factual reasons, but are you really that good at asking voir dire questions? Or writing them. So write them out and then say them to somebody, say them to your spouse, say them to your kids, say them to your dog, but just let the words come out of your mouth. So that's the second thing I suggest. So 1 is to find out who we don't want. 2 is to write the questions down. And then the third thing is actually not before jury selection, but it's once the jury's in the box, know your audience, because that is the number one, underlying factor of quality public speaking is know your audience. And so if you haven't had time to get to know these people, if your voir dire went like that and it's over and you've got 8 people in the box and you're looking at them and you're thinking, oh, Lordy, get online, look them up. Get a voter registration, see how they voted in the last election. Know that jury, get to know them as best you can. Go back to their questionnaires or go back to the voir dire transcript and look at the answers to their questions, and see what they said about themselves. Always have somebody with you in jury selection. So don't try to do that yourself either. You don't have to have a professional, but just have somebody there that's going to help take notes with you, help make observations with you, and then talk about and say, okay, we've got, so we've got Ms. Baldacci is on the jury. What do we know about her? And then you might come up with ways that she might turn out to be a better juror than you thought. If you know her, if you get to know her as you try your case and you deliver a message to her. When I was 16, before I had my own car, I could get the car keys to the family car out of my dad. I could get the car keys to the family car out of my mom, but it was 2 totally different shticks. And so you've got to be able to try your case to the different personalities on your jury, but you need to know them. So that would be the third thing, is know your jury.
Teresa, I'm gonna leave you to the question and answer because we have 2 jury questions, so I've got to go answer them.
Hurry back. We want to know what they are.
Thank you, Judge McConnell.
Yeah, thanks.
Thank you. And thank you, Teresa. So with that being said, we have about 9 minutes left. Does anybody have any questions for Teresa?
Come on.
Anybody at all? Go ahead. There's a microphone right over here in the front, if you don't mind.
Do you find that older jurors have more bias or younger people have more bias? How does that demographic break down?
Well, that's an interesting question. Age, generational differences do exist. So, for example, for about 12 years, when the patent cases were at the height of their fever, and they were being tried in like crazy all over the country, like maybe 20 years ago or so. So for 10 years, I did almost exclusively, 80% of my work was in patent cases. And we found huge generational differences in a patent case because older people believed that the patent office was a solid institution that had all these little scientists sitting around and testing things and reading patents, and younger people were more open to understanding the limitations of the patent office. So so it depends on your case. If there is a generational difference that brings with it a particular bias. Some of the technology cases that are either in court or headed for courts now, older, like the grandpa generation, I guess that's me, the grandpa generation, they are, they think that the internet is the bane of our existence. Like, why do you let your kids on that thing at all? Let alone regulating it or doing all the other things that people are looking to have happen with the internet access. So it really, really depends on your case. I mean, I've done a lot of pharmaceutical defense over the years and plaintiff's work in pharmaceutical cases, and a young person is less likely to be reliant on their medication. A young person is less likely to be reliant on their doctors. So it is case specific rather than generational, or the match of the generation for the case specifics.
Thank you. Chip?
Hi.
I think it was on.
It's on.
Okay. Thank you for your help. My question is about the most recent cultural changes. Artificial intelligence seems to be upending a lot of the assumptions we have about people and knowledge itself. And politics is sort of turning on its head. So are there any insights that you can offer from, the last 12 to 24 months that might be different from what you encountered, 8, 5, 10 years ago?
Yeah. I think I understand your question. Are you saying that is what's on the internet affecting people's positions on subject? Is that what you're asking me? I'm not quite sure.
More about whether people's attitudes are, for instance, attitudes toward government, attitudes toward big corporations, attitudes toward minorities. Just those assumptions that we had 10 years ago seem to be all shuffled up now, and I'm just wondering if there's any general insights you have as to the 2025 juror.
So it's being written about every day in every newspaper, and every commentator in the world is commenting on the upside downness of the American system right now. What we are living with is ambiguity. And ambiguity is an unsettling state for the human brain. So to answer, has anything changed? It's changing. Our research that we've done is it's different every 6 months. In my profession, we trade research that we can, that's not case specific, on people's ideas to keep each other abreast of like what's going on in the world as far as people's opinions and how to educate and how to persuade. And we are finding shifts. We're finding that people are people who may hold the minority opinion, whatever that opinion is. So I'm just saying that if you have a jury of 12 people and 8 people believe one way and 4 people believe another way, that until recently, the last 2-3 years, the 4 people were more reluctant to voice the minority opinion, to voice the opposition, to voice the dissent. And we are finding that they are more vocal. And that even in our jury research, like in focus groups, and that we're, as Judge McConnell was saying, how he's seen the one loudest person tamp down the opinion of the other person. What we're seeing is that minority, I don't mean minority in terms of race or gender, but that minority opinion on the topic, so the people voting no versus the people voting yes, are more likely to make statements, and they're more likely to make declaratory statements. If you followed how the linguists and the people that do what I do believe one of Donald Trump's assets as a candidate, both in his first election and now and second election and currently as president, is that he speaks in declaratory statements. So he just says it. The weather's bad, very bad. This is good, very good. The plaintiff's wrong, really wrong. And that is how, because we as a society don't like ambiguity, we don't want somebody to weigh. We want somebody to just push, to tell us what to do. That's becoming an easier way to get your opinion across in the jury room.
Thank you. We are out of time, but maybe we have time for one more question. Anybody on this side? Yep, go ahead. You can press it again. There you go.
Yeah, I want to get back to your point about not having the client present during voir dire,
Sure.
which I think came as a surprise to lots of us, because at the very least, lots of times we like to ask our client,
right,
what do you think about the panel, or what do you think about this juror or that juror, sometimes for various reasons. But are there any times on which you ask the client, either in advance of voir dire or at some point, what do you think about who we want on the juror, or what do you think about specific people who might be on the jury?
I would ask that question for political reasons only. I don't think they have the expertise or the perspective to make that, to contribute really to that conversation. So yes, I ask it. I've been asking it for 40 years, but I don't really weigh it.
Okay. With that being said, we are out of time. So I'd like to thank you, Teresa, for taking the time.
Oh, thank you.
Phenomenal.
I appreciate